So we're recording. This
Okay.
isn't about being
Doesn't matter about photogenic.
camera. Yeah, well, you are photogenic, as it turns out.
So do you want me to actually talk about my case for 2 minutes?
What I want is what your request is.
Right, okay.
So what's your objective?
Okay.
And then, given that objective, perhaps 2 minutes about the background or the case itself.
Okay. My objective is to actually make sure that the fraud that happened against me is actually rectified. My house was illegally transferred out of my name by fraudulent documents. My ex-wife and a bank manager actually did the transactions. The long and the short of it is that I had a house in my sole name, and I had an untraded company off the shelf that was never traded. I was the director, the secretary, and the sole shareholder of that company, and my wife at the time was the other director. The company never traded. I left the country. I was extradited abroad for a crime I didn't do, and I was released just under 2 years later. Well, a few months after I was extradited, they transferred the house in my sole name to the company's name, and they borrowed £330,000 in the company's name to be able to do that. But all the transactions of the loaning of the money are fraud. All the transactions that were made have got my name on as if I was the director and I was in the bank and I was signing for the money and agreeing to the terms and the conditions. I have some of the documents, but not all of them, but I have some of the documents which are, I have things like the waiver of legal rights, where the bank manager has signed an official document from the bank to say that I'm in his office and he's telling me to take independent legal advice before they take my home to security, so they can then process the loan, and he's signed to say I have signed it and he's witnessing my signature upon that. Now that is one of many documents that exist. I have some of them. I know that the Money Laundering Act 2003 states that since 9/11 I'm supposed to have been in the bank to open the account myself, and in the banking file that I have a copy of, I can see that they've used my passport as my identity to open the account, but the law says I have to be there, and I am not. Now, I've told the bank that I'm abroad, that I was away, and they actually agree to the fact that that's true, and they've now dropped their £330,000 claim against me in relation to when I get my house back, they'd like me to repay their mortgage. I was about to win at Land Registry when they froze that court case, and they run off to the High Court to make a Part 8 claim against me, so that when I got my house back, I had the mortgage that I once had on it reinstated. Now, because the company no longer exists, they want to reinstate their mortgage on me. And I went to the High Court, and the judge has now made an order which says that he basically agrees that they should have their Part 8 claim, but he shows in the documents that it's time that they came clean and they delivered to me the proof of the things that I say. They should state their position, is I think basically what it says, of what they think this manager did or didn't do. Now, I know that he committed fraud. I don't know how much of the £330,000 that he had, and I do know he's been sacked for it. But my position is I do not want the bank to be paid the £190,000, £188,000 by me, because they've cost me £278,000 in rent that I have not been able to claim on that property in the last 6.5 years or whatever it is. And on top of that, I took the bank using a commercial lien process through public notaries, which I've got notarized, and I've got apostilled by the Secretary of State of both Europe, in Madrid, and America. And I have found the bank guilty of owing me £3.5 million and £700 million of punitive damages. So I say, if I owe the bank £190,000, give or take a few quid, they should take it out of the money they owe me. And I think one should balance the other. On top of that, I've lost another £278,000 of rent, so they should take it out of that. But whatever it is, their actions should be... Their bank manager is governed by their insurance policy, and if he commits fraud on their premises, they should take their insurance policy and pay me off. They refuse to do that. I have yet to get the documents out of the bank. and I've tried to make a subject access request, and I paid the £10, they refused. I then took them to the ICO, the governing body, and they've tried to get the documents, but because they put the house out of my sole name into the company's name, they say I never signed the documents, so I'm not entitled to them. I don't believe that's true. They say the company borrowed the money. Now, if that's true, at the time I was a director and company secretary and sole shareholder, so I should be entitled to the documents on that basis. They won't give them to me, but I know that anybody legally minded should be able to make the proper applications and actually force them to comply and deliver the pieces of paper, the folder as such. I took counsel's opinion, and the counsel wrote to the judge and said that as far as they were concerned, there was enough evidence available to actually take a Part 7 claim, to stop the Part 8 claim, and it should go to Part 7, which means multi-track directions. In other words, I should be entitled to ask the bank to produce the documents and facts and figures, and to get them to confess which part of the fraud that they played in. So I'm really interested in somebody helping me taking this judgment and actually, because the judge is asking me at this point to agree to the draft of the judgment, and I don't want to agree to the draft of the judgment. I want to agree to it in principle, but it's not correct. Even if the bank have the mortgage, the interest level, the term of the mortgage, what's outstanding previously, I think if I didn't defend it, the bank would be entitled to their mortgage, and they would say that I owe them the last 7 years of arrears, because they've been defrauded and I've been defrauded. The main point is, it's their bank manager who signed my name on the forms, who drew the money down, who opened the account, who knew that the company resolutions were not legal because I was not there and I was abroad, and he knows I was abroad because I've seen the file from the solicitor to prove that. So what I want is justice, but I expect to be able to do that by first of all proving that I'm entitled to counterclaim against the bank's claim, and secondly produce the evidence into court that I've got and get more evidence from the fact of compelling them to produce the banking documents to show who witnessed my name, because it wasn't just the bank manager who did this, there's a whole row of people. Plus my studies have told me that the bank are internally responsible for their own security measures. In other words, if they don't produce an internal security measure to stop this kind of fraud, that they've broken their own rules and regulations. So that's another can of worms that needs to be addressed. So there you go, Brett.
So listening to you say all of that, it came across as somewhat practiced, in the sense that you've thought this through rather deeply enough times that you've refined down to what looks like just under 8 minutes the situation you were in. That suggests to me you've brought this to a number of legal-type folk already seeking help. Why are they not?
I have phoned. The government have got some kind of helpline, some kind of community, which actually says that you should do certain things, and they've got lists of people in their legal aid panel, and I've phoned 200 of them over a fortnight, and either they were busy, either they didn't practice this kind of law, either they didn't do legal aid anymore. I found that the only legal representation I could get is if I started putting £25,000 plus on the table. And because this is a case about my company, because they transferred my sole name property into a company, so therefore the company owns the property. It also owes the debt, but today I am not there. I say at Land Registry it has to be rectified back into my name. But I couldn't find legal representation to actually, without paying vast sums of money which I didn't have, to be able to put this case forward. I did speak to barristers who said this is a simple case to prove, because if I'm not in the country, I'm actually in a foreign cell, in solitary confinement, and I've got letters from the Home Office and the Foreign Office and the prison in a foreign country to prove I wasn't in the UK at the time of the signings of these things. It's obvious that every documentation is fraud. My point is, if it's now signed and countersigned by the bank, and the bank manager knows me personally and has been to my house many times, he can't say somebody else turned up and conned him. So he is part of the fraud. So I reported this to the bank in 2007, September, and I gave them every opportunity to put it right. They won't do, because that means they're going to lose their £330,000. The reason they're fighting me today is because they'd like their £190,000. I still say they owe me a lot of money. I should be able to counterclaim against what the court is deciding now. But the judge has given me the judge has basically told me that I'm not presenting my case in the format that the court can recognise. And I have no access to court precedents. I am sure there are previous court precedents where a bank manager has committed fraud, and then that case law can be cited in this case as a reason why the bank should drop their case.
So you're looking for a direct access barrister?
Yes.
Who has access to the case law database to find the relevant...
They have a thing called a bikini or something very similar, something with two eyes at the end of it, and they type it in and they can find the case law. And because I haven't got £3,000 a year to register, I haven't got access to that. That's the first thing I haven't got. But I need somebody who knows the banking laws, because if you can produce the case which says, look, the banking law says A, B and C, they did not comply. In fact, they circumvented it to make commissions, and we've all seen the banks get their knuckles rapped. Even today, they've been told yet again that they are circumventing the law to sell products. And now they have to pay another, I think it was lawyers got to pay another £500 million in compensation, because their whole process is to sell. Well, they sold me a mortgage, or my company a mortgage, knowing that the house was being illegally transferred, knowing that the person selling it wasn't around, and knowing that the person borrowing the money wasn't there to actually sign the documents. You can't get any more part of the fraud than that.
So if I was a barrister, and I just watched your now almost 12 minutes, what is it that you would wish for me to do in response? And what is the arrangement you would like to make with me as a barrister?
Well, Brad, I need help. So I don't know what financial arrangements the barrister needs, because I don't have a great deal of money, but I do have this house, and it was worth £700,000. It's worth less than that now. I mean, it was one house, and I converted it to 4 flats, and 2 of the flats are finished, and 2 of the flats are 50% finished. And that's where the £700,000 comes into it. Plus, I've lost all the rent, because the property should have been rented. And I only borrowed the money at the start from a bridging company, and I borrowed the money for 9 months maximum, and I paid the interest up front. Now the bank want to subrogate their mortgage on top of that. They will want me to pay them 1.4% interest per month, just like the bridging finance was. But I only borrowed it for 9 months because it was an in and out. Plus, I've already presented to the court documents to prove that I already had the flats revalued with mortgage offers on the table for me to sign and complete. Now, the only reason I didn't was because I wasn't there, and the bank took the property away from me by using their money to allow fraudsters with their bank manager to defraud it. Otherwise, my family left behind with my power of attorney would have taken that property and refinanced it with the mortgage offers that I'd left on the table.
So you're I mean, if I were to make it a direct assumption here, you're looking for someone who would consider operating on a no-win, no-fee.
Yes, I would love that basis.
Ideally.
Or, if they can't do that, at least give me at least look at what I've done and give me the legal terms and legal access to doing what's right. It's because the judge has asked me to present it in the right way, and I haven't done that.
So you would like, perhaps then, rather than the full whack direct barrister service, you'd like an unbundled service where the barrister thinks about the presentation that needs to be made in court, even though it may be made by you personally, and structures the presentation and the information within it in the most effective manner for you to win by presenting
and since I'm
best.
speaking to you, Brad, on camera, and you are part of the help of litigants in person, if that barrister is out there, I would more prefer him to come to the table and do this case as if it was his case, on the basis that if we win 90% of the money of the value of this house and all the compensation that goes with it, I would like to put into trust and hope that this barrister will be part of that same trust to help other people in this situation. In my brain, I've lost the house, but I do not want to to give up the injustice that's happened. And I do not want the fact that this bank manager can get away with actually committing fraud, and the bank has sheltered them from actually coming to terms with the fraud. My understanding of the law is that once I made it clear to the bank that he had committed fraud, it was then a criminal offence for them to shelter him from the police. They refused to allow the police to investigate. In fact, I've got a letter somewhere on file, which is from the Metropolitan Police, that says that after they discussed it with the bank have no reason to believe it's anything other than normal. Now, on the basis that I've already proven to the bank that I was in prison in a foreign country, how could their bank manager say that I'm in his office collecting money and drawing down and borrowing money? Plus, some barrister with banking background would know that it is illegal for the bank to lend money without satisfying itself it's doing it in the correct manner laid down by the FSA and by the consumer credit agreements. You can't lend money to people unless they know they're lending the money, and you can't get them to sign documents that they're not legally in acceptance to. So you can't even hide things. So to actually do it, and I didn't have a bank account with this bank, I didn't have a credit card with this bank, I didn't have a mortgage with this bank, I had no dealings with this bank whatsoever, apart from the fact I know the bank manager because I had a credit license for 25 years and he's been to my home several times, and he offered me money legally, and I even had this house valued by the bank, which cost me £550 because I was thinking about lending money from them, but I never did take their money. So to me, because he wants to meet his targets, he has no right in actually signing my name on documents to lend money to meet his targets, and I'm sure he had his hand in the pie collecting some of this money. But regardless of all those things, you can't lend money to my company, and even my company should be entitled to sue the bank for actually allowing it to let a rogue director commit fraud.
All right, so the last bit here for me that I'm thinking is that if you do succeed in securing a barrister who will work with you and help you come to the point where in fact you have succeeded, there are many other litigants in person who would make a beeline for that particular barrister, I would imagine. So there are a number of reasons why a barrister might want to help you.
I would happily pay him on a no-win, no-fee basis. I need to give my family a little piece of this £700,000. I'm sure the rent alone and the compensation alone from the banks, the bank's committed fraud through its employee and it's covered it up. All that has to be is proved in court, and all of a sudden 7 years of legal fighting and compensation and interest and loss of earnings and everything else can come to the table. This barrister could get paid, but I would happily allow this barrister to be part of a team which sat for litigants in person, which used this money that I leave in the pot in trust to pay his next set of court fees in advance to help the next litigant in person on the basis that they put some of their money back in the pot to help other people grow forward. Because I still think that a barrister and solicitors would like to see justice happen, especially to people like myself. If I can get them on board and we can fund them, then there's no reason why they need to go work anywhere else. In fact, there's enough money here to probably set up a new company and a new business to actually help litigants in person directly. And that's what I would like. This case should be easy to win because they've got no defence and they did wrong and they broke rules and regulations laid down by governments. And I think any barrister worthy salt should be able to find those laws that they broke, rules and regulations, put it in front of a judge and easily find them guilty.